Equal protection is one of the most heavily tested areas in constitutional law. You can be entirely confident that you'll see equal protection questions on the multi-state, and equal protection is very commonly tested on essays all across the country. This is material that you need to know. Fortunately, it's also very straightforward. You'll see that when you do multi-state questions, and you'll also see on the essays, a little bit of knowledge will take you quite a long way. Equal protection law can be quite complicated, so I advise you, don't study it very much. Get into practice, and you'll see here again, this material is tested ritualistically. Very similar issues come up over and over and over again. And if you are well prepared to deal with how this material has been tested before, you're very well prepared to deal with how it will be tested in the future. Remember, the core idea that gives rise to an equal protection claim is a discrimination. We've got to have a law that treats one group of people differently from another group of people. Within those issues, what we have to face is where there are discriminations that are being made based on a suspect class, or where discriminations are being made based on a fundamental right. And we've seen fundamental rights already in substantive due process. Well, where the government discriminates, and that discrimination involves a fundamental right, once again, the standard of review gets a lot tougher. So, when we consider fundamental rights, there's a short laundry list, and it's probably a good idea to have that list memorized, but it's far more important to be able to spot the issue when it arises on a multi-state question or on an essay. And it's a lot easier to spot the issue than it is to memorize and regurgitate endless laundry lists. This is an area of law that it is far more important to understand thoroughly than it is to be able to recite comprehensively. So, the fundamental rights. We know that voting is a fundamental right, and the right to be represented is a fundamental right. Travel is a fundamental right. The right to marry is a fundamental right, and the rights of procreation also are considered related fundamental rights. Remember, finally, that a criminal defendant who has been convicted has a fundamental right to one appeal and to a trial transcript at state expense if the defendant cannot pay for it himself or herself. There are other rights that sometimes give rise to equal protection claims. These are those arising out of economic regulations and social welfare legislation. There's not really much to say about this issue up front. Go see how it is tested, if you can find a question on the topic, and you'll see again it's fairly straightforward. When we turn to suspect classifications, here the law gets slightly more complicated, and you'll see that the standards of review are a little bit more flexible than they might seem in the abstract. But the basic suspect classifications are those dealing with race and alienage and gender, illegitimacy, etc. One evolving area of law is discrimination based on sexual preference. There is some very recent case law on this point, and it appears that discrimination based on sexual orientation is being interpreted in ways very similar to gender discrimination, an intermediate standard. Also, there is established law that certain classifications are not suspect classes. These are poverty, age, and mental retardation. Discriminations based on those qualities typically are not considered suspect classifications. The plaintiff has to show more than that. And typically, a plaintiff will seek to show more than that by pointing to one or more fundamental rights that are being damaged by the law at issue. So, that's the nutshell of what equal protection law is. But let me offer for you some ideas about how this material is tested, some details that you really do need to know and that you will see in practice. Remember, first of all, that the Equal Protection Clause does not apply to the federal government. The same ideas apply to the federal government, but the source of that law is the Fifth Amendment, not the Equal Protection Clause of the 14th Amendment. Remember that the state may impose limited residency requirements on the right to vote. But limited means defined in a matter of weeks or maybe a few months. Much longer than that, and that's an unreasonable interference with the fundamental right to vote. Remember that mere economic regulations, and anytime you want to belittle something, call it a mere whatever it is, mere economic regulations are only subject to the rational basis test. As long as the legislative authority isn't crazy, that law is going to be upheld. Only irrational economic regulations will be stricken. Remember that the right to be free from poverty is not a fundamental right. So, it's okay to be poor. The Constitution is not offended by having a lot of poor people around. And discriminating against poor people on its face is not a suspect class. Neither the state nor the federal government may discriminate on the basis of race without a compelling state interest. And the same is true for religious discrimination. Race-neutral classifications, such as zip code or social class, are valid. And although they're subject to challenge on equal protection grounds, there's very subtle law that the Equal Protection Clause is not violated. And here, the most important and the most recent case law is on school desegregation cases. It is wrong for a school to use race in order to try to achieve a racially balanced school system. But it is okay to use zip code to try to achieve the same result. And since, in practical terms, many of our cities are segregated by zip code, using zip code in order to strive for, among other things, a racially diverse school population does not offend equal protection. But using race to do so does violate equal protection. That is very recent case law from the United States Supreme Court. Remember that the federal government has a lot more latitude in discriminating against aliens than state governments do. The federal government is responsible for national security. And for foreign policy reasons, the federal government has a lot of reasons that are entirely justified for discriminating against aliens. That's not to say that every federal law discriminating against aliens will pass constitutional muster, but most of them will. On the state level, however, it is permissible for state governments to prevent aliens from getting into high levels of state decision-making. They may discriminate against aliens on those levels. But generally speaking, the states have a lot less freedom to discriminate against aliens than does the federal government. Remember that gender discrimination is valid only if an important governmental purpose is advanced and if the statute is substantially related to that purpose. That's a rough statement of intermediate scrutiny. And as you'll see, by doing a high volume of practice, which, once again, I urge you to do, you'll see that having a glib description of the various standards of review is very important for essay purposes. I encourage you to work on practice essays and sharpen your skills at weaving the standard of review into an analysis of what is at issue. Being able to do that is the core skill required for getting passing scores on bar exam essay questions dealing with constitutional rights. Remember that the states have more power to discriminate against aliens, and the last issue of discrimination that I want to touch on is illegitimacy. The state can't discriminate against illegitimate children where paternity and maternity have been conceded or established in a judicial proceeding, but where parenthood has not been established, or in cases where it has not been acknowledged at all. Under those circumstances, the state does have the right to discriminate against illegitimate children. And typically this arises in wills and trusts cases, where the state will put a time limit on illegitimate children's rights to sue as omitted children in estates. Well, that wraps it up for equal protection. But I want to briefly touch on one other area of law that deals with the individual rights guaranteed under the Constitution, and that is the privileges and immunities clauses. There are two of them, one in the 14th Amendment and one in Article 4, Section 2. The Privileges and Immunities Clause applies to natural-born citizens, not to business entities. Beyond that, there's not a great deal of material that is tested here. Have a look at it in practice. You'll see that there's a detail or two to know about, but it isn't a very high priority. Also, the Constitution protects against interference with contracts by the government. Here again, you may see a question on this on the multi-state, but many times the multi-state doesn't touch on this law at all. A bill of attainder is a bill that is aimed at punishing individuals or groups without benefit of trial. Those laws are unconstitutional as bills of attainder, and also ex post facto laws that are created after the fact to punish conduct that happened before the law was passed. These laws are unconstitutional as well. Part of what the Founding Fathers had in mind was no bills of attainder, no ex post facto laws. Those are considered core constitutional rights that are protected, individual rights. Well, that wraps it up for a consideration of equal protection. Next, we will have two videos that will deal with different aspects of the First Amendment. Next, we will consider religion, and after that, we will consider speech.